Hello, in this video, I will talk about buying property on installments. Good day everyone, I am Dean Rod Vera. I am a law school dean and a law professor at the University of Caloocan City College of Law. Today, we will discuss buying property on installments. Before we start, I'd like to remind you that this video is not legal advice but only made for educational purposes. So what you learn here today is for education, not necessarily advice. If you need proper advice, please consult a lawyer. I'm sure many of us have bought or are considering of buying real property, land, houses on installment. It's very hard for us, especially today, to buy things on full cash price. And it's easy for us, those who are earning a monthly income, to pay things on a monthly installment. It is widely known that sales by installments are quite onerous or disadvantageous to the buyer. Knowing that buying on installment could be quite disadvantageous or quite harsh on the buyers, our legislature back in 1972 created Republic Act 6552 or the Realty Installment Buyer Act. But that law is well known by another name. It's called the Masetta Law, drafted by the late Senator Ernie Masetta. In that law, it gives us protection and options for those buyers who are considered in default in paying their monthly installment. Here is what you need to know. Normally, in the year 2021, people buy real property under three types of contracts. First, what we'll talk about is the installment contract, wherein people pay a fixed monthly installment until they pay the full purchase price. Technically, that is called a contract to sell. A contract to sell, which may not include installments, means that a seller and a buyer have an agreement that once certain conditions are met, the seller will give a deed of sale or deed of absolute sale to the buyer, wherein a transfer of ownership will occur. Now, a contract to sell may be either in installments or other conditions that may be met. What's important in the contract to sell is that the seller will only give the deed of sale or transfer of ownership once the conditions, whatever they may be, in the contract to sell are met or complied with. Now, there's another species of contract to sell, which is basically called a rent to own contract. Now, I will talk about that type of contract in another video, but normally that rent to own contract will not be covered in this video because the conditions will not satisfy the requirements of the Masetta Law or the Realty Installment Buyer Act. Now, what are the requisites for that Masetta Law? First, the seller must consider the buyer in default. Whatever the conditions will be set for default, it depends on the contract. Normally, if you miss 2 or 3 or 4 payments, the seller then may consider the buyer in default. But if you're reading a contract and you're about to sign one, make sure you understand how the default is defined. All right, so the requisites to qualify under that Masetta Law is that you're buying real property, even condominiums, under a fixed monthly installment, meaning the contract will say how many months you have to pay and how much you have to pay monthly. There is a cutoff for this Masetta Law. It's 2 years. Not necessarily 2 calendar years, but you have to remember this, it's 2 years of installments. Jurisprudence or the latest Supreme Court cases have determined that the 2 years installment means monthly installment times 24 months. So if your installment is basically 1,000 a month, if you've paid more than 24,000 in installments, then you qualify under the Masetta Law, which gives you options in case you are considered in default. What are those options? First, if the seller declares the buyer in default and the buyer qualifies with those 2 years of monthly payments or 2 years of installment payments, the buyer can pay the full balance within a grace period. The grace period by law is determined as 1 month for every year that you pay. So basically, if you paid 2 years, you have 60 days. 3 years, 90 days. By using that first option and you pay the balance, it is without interest. So if your monthly balance left after declaring default is 36,000, you have to pay 36,000 without interest. Here's the second option. If the seller decides to cancel the contract because the buyer is in default, the buyer can demand 50% of what he has paid in installments. Remember, you can't do both options. You have to choose one or the other. But the second one only operates or only is effective if the seller cancels the contract. So going back to option one, wherein you can pay within the grace period, a seller has to give you that grace period in which to pay the full balance of the installments. Another sub-options on the refund of 50%. If you've paid more than 5 years, the law allows you an additional 5% for every year after the 5th year, but not to exceed 90%. A bit confusing? Well, let me explain. So if you've paid 6 years, you're allowed 55% because you have 5% for additional year over the 5th year. So if you paid 8 years of installments, 3 years over 5 years, so that's 15%. So you can get basically 65% refund. But the law caps it or stops it at 90%. What happens if you paid less than 2 years? Well, the law gives some advantages to the buyer. If there has been less than 2 years of installment payments, the seller must give the buyer a grace period of not less than 60 days to pay the full balance. So the seller has to give notice that the contract is canceled and there's a grace period from receipt of that cancellation. Now, here's what you have to remember. If the buyer does not pay within that 60 days, the seller may cancel the contract 30 days after receipt of the buyer of either the cancellation of the contract or demand for rescission. Let me repeat. The seller first has to inform the buyer that the contract is either being canceled or going to be rescinded. And 30 days after receipt of that cancellation order or cancellation notice, the seller has to cancel the contract by a notarial act, meaning the seller has to present the buyer a notarized document with an acknowledgement by a notary public that the contract or sale contract has been canceled. Now, here is the most important provision in the Masetta Law. A sales contract that tells a buyer that he cannot avail any of the remedies is considered void. In other words, even if it's not in the contract, not in the sales contract, the provisions of the Masetta Law or Republic Act 6552 is impliedly included in the contract, meaning all the options which I just said are available to the buyer in case he defaults. Remember, it's not what you know, it's what they don't know. Hi, please do me a favor and smash that like button. It'll help me a lot and it will trigger the YouTube algorithm. Now, if you have not yet, please subscribe to my channel. If you don't, my dog will eat this exam booklet and that student has to repeat his final exam again.